welcome you again to this second session. Now we are going to talk about the next stage in the nomination process, which is the scrutiny of nominations and then withdrawal of candidates and ultimately the drawing up of the lists of contesting candidates. Scrutiny of nominations is a very technical aspect, and a very small technical lapse or a mistake on the part of the returning officer can vitiate the whole election process. If the nomination of a candidate is improperly rejected, the law says that the election will be ab initio void. Nothing else is to be proved by the defeated candidate except to prove that the nomination was not properly rejected, and then the man who has won, his election will immediately be set aside, nothing else is to be proved. But if the nomination paper is improperly accepted, I mean it has been accepted which in fact should have been rejected, that does not meet with that fatal consequence. In that case the law says that the candidate who lost has to prove that the man whose nomination was improperly accepted, his votes should have come to me and would have come to me, and then my votes would have been more than the winning candidate, which is almost very difficult. So our advice always from the election commissions is that you err on the right side. Unless you are 100% sure about the nomination paper of a candidate is not proper, I mean that needs to be rejected on some very special grounds, then only you go for that. Otherwise you give the benefit of doubt, as they say in cricket, the benefit of doubt should go to the batsman. Similarly here also our batsman is the candidate and you give the benefit of doubt to him, let him contest, and then ultimately the voters will decide. But this does not mean that even where you are satisfied that the nomination ought to be rejected, you still say okay, you just contest. That is not there. But at the same time you must be very sure about the ground of rejection. And the scrutiny of nominations is a quasi judicial function. The returning officer plays a very crucial role, and the law says, and the Supreme Court has also upheld, that it is a quasi judicial function, and in the performance of this function the returning officer has to apply his independent mind. He cannot be guided by any senior officers or even by the election commission's officers that you do like this or don't do like this. You have to, of course you have to apply your mind, you have to see that all the instructions, directions, all the provisions of the law are fulfilled. If any clarification has been given by the election commission, you keep that in mind. If any decision of the Supreme Court or the high courts have been rendered on that point, you have to keep that in that mind. But you cannot go by any direction or any instruction of the district election officer or maybe chief electoral officer or even by some officer in the election commission. You have to apply your independent mind, and wherever some objection is raised you have to give a reasoned order, because that is subject to question, and in the election petition that can be ground for questioning the election. So you must record your reasons. Now starting with scrutiny proceedings, the date of scrutiny, as I have said, is already specified in the election commission's notification. You can't change it. Supposing some situation arises where on a particular day the election commission specified a day as the date of scrutiny, and then later on that is declared as a public holiday, then you need not be worried about this. We will take care of that situation, and the election commission will issue the revised notification fixing the next day. So, on your own you cannot postpone, and then as I have said that you have already fixed the time for the scrutiny and also the place. So, do not change that place and time, otherwise people will allege that you gave us this place and you started the proceedings somewhere else, and so the scrutiny was done at our back, or you gave us the time at 11 o'clock, you started at 10. So, do not change those dates and times and place also. The question arises then, who can be present at the time of the scrutiny of nominations? The law says, that is again mentioned, I just mentioned one point, the scrutiny of nominations is governed by the provisions of section 36 of the Representation of the People Act 1951. So, in that section itself it is written who can be present. Only 4 persons. So, becomes attributable to the candidate. So, he appoints one person as a person of his very great confidence, and that appointment he makes in form 8. He makes that appointment in 2 copies of that form. One form you will be retaining with yourself, because he has to present that form to you, and the other you will have to give it back to him with your endorsement that you accept this appointment. Our instructions are that on that form itself the candidate will fix the photograph also of the election agent, so that there is no problem in identifying that man, because he may be moving from place to place, he may be making appointments of polling agents, counting agents, he may be maintaining his account of election expenses, and our instructions are that you put a seal on his photograph in such a way that half of it comes on the photograph, the other half comes on the form, so that it is not replaced also clandestinely by somebody. So, that election agent can be the third person. Then in addition to these 3 persons, he can bring one more person of his own choice. Normally you will find that particularly those who are very keen, they will bring some advocates with them, or some persons who know election law or procedure, or some leader also sometimes they may bring, but only one person they can bring more. So, these 4 persons can only be there on behalf of a candidate at the time of the scrutiny. But supposing at the time of scrutiny you find that none of these 4 persons is present on behalf of a candidate, it is not necessary for you to adjourn or to postpone the proceeding because nobody is there. No, it is his responsibility. We have told you that you come on this day, you can bring these 4 persons. So, it is up to you, whether you are there or not. If any objection is raised in his absence, then he will be the sufferer. Then as I said, it is a quasi judicial function, and the RO must do this function himself. The law says that the ARO can do all the functions of the RO, but not the scrutiny of nominations. It is provided in section 22, where the provision for the appointment of the assistant returning officer is in the law. So, he can perform all the functions, but not the scrutiny. But a situation may arise, supposing something goes very seriously wrong with the RO on the day of scrutiny, and we can't postpone this process. So, in that situation alone, the ARO can be given that job. In that case, the presiding this RO will have to give a written instruction that because of these special problems I am not able to perform this function, and then the ARO is authorized to perform this function, but this should be avoided as far as practicable. Then you have to scrutinize on the date of scrutiny all the nomination papers. What our advice will be that you know at the end of the 7th day or 8th day as to how many nomination papers have been filed in all, and you also know how many nomination papers have been filed by each candidate. One man may be filing only one, another may be filing 4. So, what we would advise you that just a day before the scrutiny, on the day previous to the date of scrutiny, you club all the nomination papers of one candidate together. Supposing somebody has filed a nomination paper at serial number 4, another he filed at serial number 11, then third and fourth he filed on the next day or maybe later as 15 and 16. So, it is no problem if you just keep 4, 11, 15, 16 together. You start with 1, and when you come to 4, then you scrutinize the 4 number nomination paper first, and then as soon as that is over, then you can even take up the nomination of the same man as 11, 15, 16, so that the nomination papers of all the candidates, because all papers may be available in one nomination paper, others may not be having the receipt, security deposit or the oath form or the electoral roll. So, all papers will be available at one place. So, you can just keep them together and one by one you have to scrutinize. But if you accept the first nomination paper, say he has filed the 4th nomination paper, you accept, but that does not mean that you will say okay, now it is okay, why should I scrutinize this 11th, 15th, 16th. You have to again scrutinize 11th, 15th and 16th individually. You have to pass an individual order again on each of those nomination papers, because it is quite possible the first may have been wrongly accepted, whereas the 11th may have been properly accepted. So, in the case of an election petition, the candidate will take refuge under that acceptance of 15th, 16th, 11th, because he has to prove that not merely this nomination was rejected properly, nomination whole was improperly accepted. So, you have to pass individual orders on each of those nomination papers, even if somebody has filed 4. Then there may be some objections when you take the nomination papers one by one. Some nominations you may be able to accept straightway, because no objection, you also feel that there is no problem, you can just accept, all papers, all requirements are filled, then you accept that one. But in some cases there may be some objection by the others, saying no, this is not properly filed, the proposer is, number of proposers is less, or the security deposit he has not made or something, some on any ground. Then you have to hear the complainant. Complainant will be the other candidates naturally and those who have come with them. So, you have to hear them, then you have to give the chance to the man against whom that objection has been raised. You have to hear him, then you have to pass an order. A speaking order you have to pass. Even if you accept, this will mean that you are rejecting the objection. If you accept the nomination despite the objection being raised, this means the objection is being overruled or the objection is being not accepted. So, that also you must record your reason as to why you are not accepting that objection and you are overruling that objection. So, that also has to be put in black and white. So, you have to pass an order, and then the question arises, who can raise the objections? The candidates and their companions who have come from the other side, they can raise objections. But if you have something, some special knowledge about certain person, then you can also suo motu raise the objection if somebody else has not objected. But you cannot say that because nobody objected, so I also did not raise an objection, though I knew that this man is having some disqualification. You have a right and rather a duty to see that the no person who is not qualified or a person who is disqualified becomes a candidate. So, you can also suo motu raise the objection. then if an objection is raised and then immediately the person is there and if he can rebut it, it is okay. But supposing he says I have some problem, somebody says that he was say convicted and the other person says yes I was convicted, but then later on by the appellate court I was acquitted. Then he says you give me time, I will just go and bring that copy of the appellate court's order. Then you can give him time, and in that case you can adjourn the scrutiny proceedings, but only for that man, not that you will say okay everything is now postponed. You adjourn the scrutiny proceeding only for that man. And what is the ultimate time up to which you can say adjourn the proceedings? That is till the date of the withdrawal, because when the withdrawal date is over, then we have to come to a conclusion of the particular this process. So by that time everything will be should be settled. So you can give the time for the adjournment, keeping in view that you may be required to hear the man on the date of withdrawal, how much time you will be needing for recording your order and all that. So keeping that in view, you can say supposing 3 p.m. is the withdrawal deadline. So you can say okay I am giving you time up to 10 o'clock. So you come with all your papers, so by 10 you must come, and then you have to conduct the inquiry and then record your decision with regard to that person's objections. So you can adjourn, but up to the date for the withdrawal, and that too well before 3 p.m. Then there are certain apparent reasons on which naturally you will reject or you will not accept the nomination. Person is not qualified or a person is disqualified. As I told you earlier, the crucial date for determining whether a person is qualified or is not disqualified is the date of the scrutiny of nominations, not the earlier date. There may be a situation when a person may be not qualified on the day he has filed the nomination, but on the date of scrutiny he may be qualified. I am just giving a small example. Supposing a person is say 24 years and say 363 days when he files the nomination, but on the date of scrutiny he has completed 365 days. So on that day he is 25 years. So you have to see what is the position on the date of scrutiny of nominations. Then next ground will be where nomination paper is not signed, candidate has not signed, though the proposer has signed, but the candidate has not signed. Then you can't accept a paper which is not signed by the candidate. Similarly, you cannot accept a nomination paper which is not signed by the required number of proposers. Then our security deposit has not been made. Then security deposit has been made, but by say through check or through some other means which is not permissible in law. He has to give you the security in cash. So he cannot just annex a check of say 10,000 rupees with you. So you will not accept that. Then he has not given you the certified extract from the electoral roll if he is contesting election from another constituency. For that, of course, the law says that when you take up the scrutiny up to that time, he can produce. Then he has not given you the affidavits, or he may have given just one affidavit, not the second. Then this is a ground, because Supreme Court has said this amounts to disobedience of the Election Commission's Supreme Court's own order. So, but as I said, if the affidavits are given but the information is not complete, or the application or information given is defective, or he has suppressed some information, that is not a ground for rejection. You be very sure on that aspect. And sometimes we have seen, particularly in these affidavits, some people just give the affidavit leaving so many columns blank, and then they leave it to the interpretation as to whether this information is nil or some suppression. So our instructions very recently we have given that when the affidavits are filed, you put somebody, some responsible officer, he should go through that affidavit. If any column is left blank, you ask that man, either you put dash or not applicable or something, don't leave this blank straight away. So you must ensure that the affidavit is properly filled, giving the information, either nil information or the information which is available, not leaving any column blank. And then somewhere the candidate has not given the complete address, and the people are not sure as to who is this man, where he is living. In one case somebody said this particular market, but where in that particular market, where shop, which shop number. So the Supreme Court said no, this is not the address. A person cannot be just hunting where you are in that market. So they have to give the complete address or complete residential address, or wherever the address he has shown in the nomination paper, that should be complete address. And then naturally if it has not been filed within those 11 AM to 3 PM or on the date which is already over, so you can't accept, so that will be another ground. But at the same time, the section 36 also says that don't reject a nomination paper simply because some information which was to be given he is not properly given. So it's not a defect of substantial character, and the rules clearly say that if somebody has one of the examples given in the rules of a defect of non-substantial character is that a person has not filled his declaration with regard to the symbols. Supposing a person has to say these are the 3 symbols of my choice and he has not filled, or supposing he has filled those symbols but shown some symbols which are not even available in the list of the specified symbols. So that is not a ground for, so you have to just see. And then somewhere they have said, in 1 or 2 cases they have said that a person has given the serial number and the part number etc. of his proposers, and those proposers and the serial numbers, when they were checked, they were not correct. The part number was not right or the serial number was not right. Then in that case Supreme Court has said that if the candidate is available or his agent is available and he can give you the proper information that by mistake I showed this part number or the serial number maybe from the earlier roll, but now this is the exact number, and if you by reference to that electoral roll you can find out that yes this is the, then you can ignore that. That they have said is will not be treated as a defect of substantial character. But at the same time they have also said it, a candidate is not available and on the scrutiny and the verification of the nomination you see that he has said my proposer is at serial number so and so and part number so, but that is not there, somebody else's name is there and the candidate is also not there. Then there is no responsibility on the part of the RO to just go through and then find out whether the man is registered somewhere. If the candidate is there, he can assist you and in location of the right man, it's okay. That is not a defect of substantial character, but if he is not there, it's not your job, and then it will become a defect of substantial character. So this is what you have to just see at the time of scrutiny. And then as I have already explained, wrong information in the affidavit is not a ground, but the total absence of information is the ground for rejection. Then after the scrutiny is over, then some nominations have been accepted, some have been rejected. The RO has to give a complete account, and then whatever nominations he has accepted, he has to prepare a list of the validly nominated candidates. For that the rules prescribe a particular form which is known as form 4. In that list you have to prepare, in that form you have to prepare the list of those whose nominations have been accepted. How this list is to be prepared and then what will be the arrangement of names, alphabetical arrangement, etc., that I will tell you when we talk of the list of contesting candidates, because both the things are to be done in the same manner. So I will postpone it for the time being and tell you how the names are to be arranged in that list, alphabetical arrangement, that when I talk about the list of contesting candidates. Then we now come to the stage of the withdrawal. After the list of contesting this validly nominated candidates has been prepared, you have scrutinized the nominations, you have accepted some nominations, you have rejected some nominations, and then the third stage of this process, namely the withdrawal of candidatures, comes. Any person whose nomination has been accepted by you and whose name is included in the list of validly nominated candidates, he has an option to withdraw. He may not like to contest, maybe for any reasons. So he has the option to withdraw, and if he wants to withdraw, he has to give the intimation to the returning officer. In such case of withdrawal, this withdrawal can be made only by the candidate himself. Supposing some proposers have proposed the nomination, they cannot say no, we don't want to propose you, no, so we are withdrawing your nomination. They have no right. So only the candidate can withdraw, and for that he has to he has to follow certain prescribed requirements. Firstly, he has to give a notice to the returning officer in a prescribed form which is known as Form 5. In that form he says, I am hereby withdrawing my candidature. Here you have to see, he is not withdrawing his nomination paper, he is withdrawing his candidature itself, because he has become a validly nominated candidate. He says, I don't want to contest, so he is withdrawing his candidature. That form has to be given by him, and then that form has to be given by him. Either if he wants, he can even give immediately after the scrutiny is over, he can say, okay, I am not contesting, you take my list. But in that case, you first will include his name in the list of contesting candidates, then only you will take the Form 5. Then on the next day also he can give at any time, and for that there is no time limit prescribed that it should be between 11 and 3 p.m. So if your normal working hours are say from 10 a.m. to 5 p.m, any time he can come and they give you his withdrawal notice. Then on the next day he can do that only up to 3 p.m. That is the date fixed by law, and in the Commission's notification, that we cannot extend. But in that case, during this period, the Form 5 must reach you. But how that Form 5 should reach you? For that also there is a prescribed restriction. Either the candidate himself should come and give you that Form 5. Then in that case you will accept. Or the second contingency is that the candidate himself is not coming, but he can send it through either his election agent. I told you who is the election agent who has been appointed by him in Form 8. He can come with that particular notice of withdrawal, or any of his proposers can also come with that notice of withdrawal. But that notice has to be signed by the candidate himself, not that by the election agent. And in such case, merely presentation of Form 5 alone is not sufficient by the proposer or his election. That man also must carry another letter also from the candidate authorizing that man, saying, yes, I hereby authorize particular this gentleman who is my election agent or my proposer to give you my notice of withdrawal. So in that case, two papers will be required, Form 5 plus a written authorization from the candidate that I am authorizing, and only that man can come. He authorizes say one proposer X and the proposer Y comes, that you will not accept. So you have to see whether who has presented, and if you are satisfied that this has been validly presented, then at the end of the day you will give that these are the persons who have withdrawn their candidature today, and that notice is given in by you in form 6. So that way you know these were the number of validly nominated candidates, these are the candidates who have withdrawn, and now the remaining are the contesting candidates. So if you have prepared, I will show you or tell you how. If you have prepared the list of validly nominated candidates in a particular given order, then whosoever is withdrawn will just strike out that name, and the remaining will become the list of contesting candidates. But in that list of contesting candidates, you have also to do one thing extra. You have to specify the symbol also which you have allotted to that candidate. That also you have to specify in that list. That is list is known as list in form 7A, and that list of contesting candidates 7A, when you prepare, you have to send immediately to the chief electoral officer, you have to send it to the district election officer, because the chief electoral officer will be arranging the printing of ballot papers, or and then the district election officer will be arranging the printing of postal ballot papers and other things. So immediately that has to be sent, and then it will be immediately posted on the website also. And nowadays everybody wants to know through the internet also who are the candidates, even people sitting outside the country also are interested sometimes. So that has to be done immediately, and then when you give this this particular form 7A, then the responsibility is for the chief electoral officer to collect all the forms from the ROs in his state, and then he publishes them in a gazette. In the state gazette it is published by him. In the case of the Lok Sabha, we publish in election commission publishes it in the Gazette of India, and of course the chief electoral officer publishes it in the state gazette, and in the case of the assembly elections the chief electoral officer publishes it in the state gazette, and it is his responsibility. So you have to immediately send that list to him. One thing more about this notice I would like to add, notice of withdrawal. Once he has given the form 5, then he cannot withdraw it again, saying, oh sorry, I gave this form 5 tomorrow, yesterday I had given you this notice of withdrawal, but now I have decided I will contest. No, he can't do that. Once he has given you the notice of withdrawal, he can't take it back, it is irrevocable. Other things I have explained, only thing is previously in the earlier stages, I just want to add, in the earlier stages in the first election there was a provision for retirement. After the last date for withdrawal is over, then somebody will say I am not interested, then he will give you a notice, I am withdrawing, I am retiring from the contest. So now there is no provision. So once that time for withdrawal is over, for all practical purposes he is a contesting candidate. Whether he wants to contest or not, that's his, he may not, he may be just now propagating for somebody else, but for our purpose he is the contesting candidate. And there of course somebody will talk to you about some dummy candidates being put up, how they are now putting up those candidates just to give some extra permits for the vehicles and all that. But we are coming out with some instructions as to how to stop this wrong practice. So that somebody will explain to you later. So this is how the withdrawal and then the notice has to be given. Then I have told you this this list of contesting candidates will in fact mean the list of validly nominated candidates minus the names of those who have withdrawn, and then the remaining will be the list of contesting candidates. But as I told you about the then first I will tell you as to how the names of the candidates are to be arranged in the list of contesting candidates, and it will start with the preparation of the list of validly nominated candidates. Then it will be followed in the list of contesting candidates. If you have a look at form 4 and the form 7A, then you will find that that form is divided into 3 categories. Previously what was the position, that supposing there are 13 candidates, all the 13 will be clubbed together and alphabetically their names were arranged. So it is quite possible a person with A, an independent, may be coming at the top of the nomination this list and also in the ballot paper, and a recognized party may be candidate somewhere 7th or 8th or somewhere. So now the law is changed. If you see section 38 of the act, it says now the list shall be prepared in 3 categories. In the first category, the names will be arranged of those who are the candidates set up by the recognized national and state parties, and there both will come together, not that the national will come first and then the state will come together. Their alphabetical arrangement, supposing there are 2 from the national, 2 from the state parties, all the 4 will be arranged in the alphabetical order. It is quite possible state candidate may be coming first, national may be coming later. Then we come to the second stage, where again the alphabetical arrangement will be between those candidates who have been set up by the registered parties which are not recognized. Then ultimately the names of the candidates who are all independents, but the serial numbers will be run on. Supposing in the first category there are 3, then in the registered parties there are another 3, so it will not again be 1, 2, 3, but it will be 4, 5, 6. So this, because this is very important now, because on the ballot paper and on the voting machine you will put their names and their serial numbers, and the machine recognizes only the serial number now. They will machine will say serial number so and so, how many votes polled. So this is very important, and alphabetical arrangement has now become a very important thing, and you cannot combine one category with the other one. Then alphabetical arrangement, normally we go by the alphabets of the official language. In the case of the state assembly, in the case of the Lok Sabha, we go by Hindi. So when you arrange in the say first category, you will go by the alphabetical arrangement. For alphabetical arrangement, you go by the full name. Supposing I will just give you my example. My name, full name is Surinder Kumar Mendiratta. If I write my name as Surinder Kumar Mendiratta, my determining alphabet will be S. But supposing in my nomination paper I write S.K. Mendiratta, then S and K will be ignored. Then M will be the determining. Initials are ignored, and then full name. But supposing there may be 2 candidates, and then having almost similar name, then of course again the same thing will be there, and in that case we will even like to distinguish their names with some address or some father's name or some additional information. Then here one thing more, there may be some AP Parthasarthi and there may be some SK Parthasarthi. If we go by Parthasarthi P, then both are same. In that case the initials will become the determining. AK will come first, SK will come later. So that there the initials will also become relevant. Then normally requirement is that the name of the candidate in the list of validly nominated candidates, this will apply to the first with the validly nominated candidates. What I am talking is the list of validly nominated. So you will show the name of the candidate as he is given in his nomination paper, and there is also a process in that form itself saying that these are my name has been correctly spelled in this language, etc. So you will adopt that one. But then the rule has also given some discretion to some candidates. Supposing somebody is known, he is given say AP Parthasarthi as his name, but he says I am known in the constituency as Professor Parthasarthi or Professor or a Doctor AP Sarthi. or he may be some military officer, he will say Lieutenant General Rawat. So in that case we have said that if you are satisfied, it is subject to your satisfaction. If you are satisfied that yes, this man what he is telling me is correct, then you can permit him those appellations or surnames or the honorific titles to be added to his name, but that will be subject to your satisfaction. Secondly, this request should come to you before you have drawn the list of contesting candidates. In the list of validly nominated candidates you may have shown his name as in the nomination paper, but before you are going to prepare the list of contesting candidates and somebody comes with a request that please change my name to so and so, Professor so and so, because the whole constituency knows me by that name, and if he gives you some evidence to satisfy you, then you can add. But in that case this particular addition will not change his serial order. So professor, wherever his name was earlier coming, that professor will be ignored for the purpose of determining the alphabetical order. So that is what you have to do. So this is how you have to correct, and then some person may say that my name is not correctly spelled in the electoral roll, it's not ready, or REDD, why is my name is written, or ADD or something, or so you can correct, you can ignore those things. So I have explained that it is subject to your satisfaction, and we have seen in many cases if a important leader is contesting an election, we have seen some people will try to catch hold of some people having a name which very closely resembles. So just to create a confusion in the mind of the people that whether this man is the right candidate or the other man is the right candidate. So you have to be, first you have to be satisfied, yes, this particular thing that he claims to be this man is actually he is known by that name or not. And now of course slightly it's easy because names of the previously all names were clubbed together, now at least the names of the contesting candidates of the recognized parties are coming first, and then the names of the independents are coming lower. So there may be some separation of names also, that confusion to some extent is slightly reduced. That I have explained.